Hi guys, so the US has made some changes to their permanent residency and citizenship. I know some of you may have heard it, but for those of you who have not heard it, this is absolutely good news for some children who are currently in the US but do not have citizenship. And this is also massive good news for spouses of US citizens who are currently in the US illegally. They do not have citizenship. I've got some massive news for you. If you're interested, stay tuned. Stop that. So hi guys, for those of you who are seeing me for the very first time, my name is Nanelle Griselda. On this channel, I talk about nursing, I talk about migration, I talk about opportunities for people to relocate abroad and life in the UK as an immigrant in general. So if these are topics that interest you, please consider subscribing. I am not an immigration advisor. Do not let this replace proper immigration advice. Always seek the opinion of an expert in this field. This is just purely based on my research on the internet, okay? So the US Citizenship and Immigration Service, also known as the USCIS, they have just recently announced changes to the rules for some individuals applying for permanent residency in the US and for citizenship in the US. So there are many changes, but I'm going to just focus on the ones that I like most, okay? And then for the rest, I'll just read through them, and then I'll leave links in the description for you to go and read further yourself. There's going to be further details with this particular new rule as time goes on, okay? But for now, this is what we have. And then this is published by the US Citizenship and Immigration. They announced that on 19th of August 2024, they'll begin accepting applications for a previously announced new process to help non-citizen spouses and children of US citizens to apply for lawful permanent residence without leaving the country. This process is known as the process to promote the unity and stability of families, okay? So to be able to be considered for a discretionary grant of parole on a case-by-case basis under this process, applicants must, okay? So to be eligible to apply for residence permit under this particular new rule, first of all, you should be present in the US without admission or parole. You should have been continuously present in the US for at least 10 years as of 17th June 2024. And then you should have legally married to a US citizen as of 17th June 2024. And you should not have any disqualifying criminal history or otherwise constitutes a threat to national security or public safety, and otherwise merit a favorable exercise of discretion. So these are the 5 eligibility criteria. So to benefit from this new rule, there are 5 things that you have to meet, okay? You should be legally married to a US citizen. Obviously, you should have a legal marriage certificate to prove this. You should have been continuously present in the US for at least 10 years as of 17th June 2024. And then also, you should not have any criminal record on your case, or you should not pose any threats to public safety. And you should be present in the US without any admission or parole. So it doesn't matter if you came on a visit visa and you have overstayed for the past 10 years and you're still there, okay? If you meet all these requirements, you qualify to make your application, and your application is going to be looked at on a case-by-case basis, and then they're going to grant you your permanent residency if you qualify under these rules. Why are they doing this? They are doing this because they said they want to promote the unity and stability of families, okay? There's another guidance when it comes to children's citizenship. There's also an update on the guidance for children's citizenship, but I would go through that as well and pick a few things for you. The US Citizenship and Immigration Service is saying that they may also consider certain non-citizen children of requesters, okay, under this process if as of 17th June 2024, they were physically present in the US without admission or parole, and they have a qualifying stepchild relationship to a US citizen. So let's say you are a man, okay, in the US, you are a US citizen, and then your wife came to visit you on a US visit visa, and your wife has overstayed, okay, for the past 10 years. As at 17th of June 2024, they were over 10 years, okay? They have not posed any threats to society, they have no criminal record, blah, blah, blah. They qualify because the US government, they want to promote family stability and unity. They qualify now to submit an application. They're going to look at this application case by case cases, and if successful, they're going to grant your wife permanent residency. Okay, so this is really good. And also, if your wife, let's say, has another child with somebody who is your stepchild, and this child also did not qualify to apply for citizenship earlier, now this child also can request and make an application. Under this new rule, if as of 17th of June, this child, your stepchild, was physically present in the US without admission or parole, and they have a qualifying stepchild relation with you, the US citizen, they also qualify to put in application. So more information about the eligibility criteria, they said they'll keep on updating us in the future, but this is massive good news. If you know anybody, any uncle, auntie, niece, cousin who qualifies under this is the best opportunity, this is the best time. They should start gathering all their evidences. If they do not know, like I said, I'm not an immigration advisor, they should get, there's so many good immigration advisors in the US that they can contact and then help them build their case, because they'll start taking applications from the 19th of August 2024, which is very, very soon. There's also an updated guidance on children's citizenship. It says, effective July 18th, US Citizenship and Immigration Services has updated guidance on the US Citizenship and Immigration Service policy manual regarding provisions for children's acquisition of citizenship. So the guidance clarifies that, for example, in a case where a child is born out of wedlock to two US citizenship parents and cannot acquire US citizenship from the father, the mother meets the requirements by demonstrating 1 year of continuous physical presence in the United States or one of its outlying possessions before the child's birth. They also affirm that for purposes of acquiring US citizenship at birth, they require that a parent must be recognized as a legal parent of the child by the relevant jurisdiction at the time of the birth. They are also saying that they accept a valid and unexpired US passport or a consular report of a birth abroad as evidence of US citizenship. So if you give birth, you know US operates citizenship by soil, the just solely. So if you go and give birth on a foreign land, they would confirm or accept a valid unexpired US passport or a consular report of birth abroad as evidence of your US citizenship. However, they will also determine whether the applicant properly acquired a US citizenship and, if necessary, may request that the Department of State revoke the US passport or cancel the CRBA before USCIS adjudicates an application for a certificate of citizenship. So they've made so many clarifications on citizenship when it comes to children. For instance, they said they are also clarifying that for purposes of an application for naturalization filed under the provision for children of a US citizen who subjected them to battery or extreme cruelty, a stepchild relationship with a US citizen step-parent does not need to continue, or is this at the time of application for naturalization. Also, just so you know, if you have already submitted an application to apply for permanent residency or citizenship in the US and your application was denied or refused prior to this new rule, and now you meet the requirement, you can still go ahead. I have read about it. They said even if your application was denied earlier and now based on this new rule you've realized that you meet these requirements and you're eligible to apply, you can just go ahead and apply. But I know some people do not want any trouble. They'll rather get an immigration advisor just so that it doesn't go north. Especially if you have a very complicated process, it's always good to go with an expert to make sure that everything is fine. It's not easy being an illegal immigrant. There's a documentary on Netflix, and this documentary is about living undocumented. It's so stressful. So this is good news because I know so many people qualify to apply under this new rule, and I wish everybody the best in the application. Please don't ask me which immigration advisor I recommend. I don't know anybody who's an immigration advisor in the US, okay, who can do this for you, but do your own research and be diligent, and I wish you guys all the best. If there are any further updates, I'll definitely bring it to you. Okay, thank you so much for watching. Bye.